he is Rwandan. He himself agreed that he was Rwandan when he he appealed to the East African Court. He said that though he's a Belgian citizenship, he can be tried by other courts related to Rwanda, crimes committed in Rwanda. If they say that the prosecution said he could not be tried in Rwandan courts based on paragraph 71, that was not true, because that section says this. In 2010, a case was open for Rusesabagina, who was accused of creating a paramilitary organization. He was head of the FDLR fighters. Prosecution says that, as we see in that section 71, given that Paul Rusesabagina, who resided in Belgium as a citizen, could not be sent to Rwanda to be tried, Rwanda's prosecution opted to send the case to Belgian's prosecution so they could try him. And in 2018, after terrorism attacks by MRCD FLN who attacked Rwanda, the prosecution started another case for other people, many people involved in terrorism acts, which case was brought before this very court, which was never sent to Belgian prosecution. That's why prosecution wants Paul Rusesabagina to be they collaborated with Belgian courts, and there was a search in they also sent some evidence to those cases in Belgium, but this very court is not trying that same case. The prosecution, the defense also said that there was a problem within the collaboration between Rwanda and Belgian courts, and that's not true. Both prosecutions continued to collaborate to exchange information, and the Rwandan prosecution asked the Belgian counterparts to stop prosecuting him on the 2012 dossier. So the Belgian prosecution sent their Rwandan counterparts all evidence and documents that they had received from the latter. They concluded saying that what Rusesabagina and his lawyers say that this court lacks jurisdiction is irrelevant, because according to the law, he can be tried. It's not because of how he was arrested or how he was detained. Nsabimana Calixte and his lawyers say that a lack of jurisdiction mentioned by Rusesabagina is irrelevant, because they find that this very court has competence, has jurisdiction on this case. He says that he's not Rwandan, and it's not true. They say it's not true, because when they started that war, he wanted to be president of Rwanda, and he could not be president if he were not a Rwandan citizen. This is how this court finds this. Rusesabagina Paul is accused of creating MRCD, heading FLN MRCD. It's a military organization based in neighboring countries that has been attacking the country in Nyaruguru district, Nyamagabe, and Rusizi districts. Even though he and other leaders of that organization were outside of Rwanda, they have supported those terrorist attacks. Before the trial of this case, Paul Rusesabagina and his lawyer said there was an issue with this High Court Chamber of International Crimes and cross-border crimes, saying they lacked jurisdiction because that prosecution has sent the dossier to Belgium for those crimes by Belgian crimes. saying that they agreed that he could not be tried in Rwanda because of his Belgian citizenship obtained in 27 July in 2000. In 42, paragraph 2 of the law 30/2018 of June 2018, it stipulates that this High Court chamber has jurisdiction to try, in the first instance, anybody, both nationals and foreigners, organizations and associations, non-governmental associations, accused of having committed crimes on Rwandan territory, crimes of international nature or cross-border crimes. When we analyze the content of that article, the court finds that this chamber has jurisdiction to try anybody, either Rwandan or foreigner, accused of international crimes and cross-border crimes, including terrorism, wherever he commits those crimes, whether in Rwanda or in another country. This chamber finds that Paul Rusesabagina is accused of terrorism acts in different countries. It finds that Rwandan laws stipulate that when one of the acts is committed outside of the Rwandan territory, it's called a cross-border crime, as per Article 14, Section 2 of the Law 68/2018 of 30th June 2018 about crimes and punishments. What's in this article is similar to what's mentioned in Article 3, Section 2 of the United Nations Convention about international crimes, signed in New York on 15th November 2000 and confirmed by the Presidential Decree number 158/01 of 31st December 2002. The court finds that based on what's in Article 9 of Law number 68/2018 of 30th June 2018, the crime committed on the Rwandan territory is called such if one of the acts is committed on Rwandan territory, when it's committed by a Rwandan against a Rwandan, or if it's committed by somebody aboard a boat, a Rwandan boat, even if the boat is in international think they're here now. So the registrar will note that all the parties are present, the accused are present, and their defense teams. The prosecution is here represented by prosecutors who were here last time, and those who are here for compensation, they're present, and they're lawyers. So the trial is going to continue.
Ndabona Maître Gatera asaba ijambo baratuvuze ko twakomeza iburanisha.
Maître Gatera demande, Maître Gatera wishes to take the floor.
Ngira ngo icyo nibagiwe kuvuga.
I forgot to say that about Rusesabagina, there is a new lawyer, Mr. Rudakema Felix, who is in the defense team, on the defense team. So, Mr. Rudakema, you are part of the team.
Umwanditsi yabava iruhande kugira ngo naba baretse nimba ari icyo muvugana muvugane nta.
Registrar, please take your seat so that there are no more interruptions.
Murakoze, Monsieur le Président.
Thank you, sir. Mr. President. Mr. President, I have two items to raise. First, about the decision that we have just, the conclusion that we have just heard that had been read. I should like to request that the registrar, that my client,
ubujurire butanzwe kuri bene iyo nzitizi ubujurire butegereza.
So as I was saying, my client is appealing as regards the substance. So, Mr. President, can the registrar please register that we are appealing? A second issue, Mr. President, still concerning the conclusion.
Nuna.
Decision. The decision, not the conclusion. Still concerning the decision, before we learned of this decision, and as you yourself concluded, we had no other objections to raise, or rather, we had no other opportunity of raising objections, because for us, we were still waiting for the decisions. We were waiting for the decisions so that we can raise our voice. So, Mr. President, honorable judges, we have other objections that we shall submit this afternoon. Sorry, I lapsed into French. So this afternoon we'll submit these objections, or as soon as this session ends, sir, we shall commence the writing of the presentation of these objections as soon as possible. So, as regards based on the principle of contradictory arguments, we think we should be heard and a reply given to us, so that we are then in a position, whenever you respond, so that we're in a position to present or to defend our objections, including the written decisions with all the conclusions that are required. Now, some people may think that we're just delaying. We're just delaying the case. Sir, you have the right. You have the right to. No, Mr. Chairman, I was just saying, just explaining my objection. But it is clear that it's not our position. No, there's no such position. Your arguments, you have a right to present them. We had made it clear at the beginning of this process. Yes, thank you, Mr. President. No, I was saying, I was replying to what you were about to say, that maybe some people were suspecting you of delaying, playing delaying tactics. And I was just saying that this is not the position of this court. There may be others who may have thought so, but the position of this court is that you have a right to make your objections. Thank you, Mr. President. Well, therefore, we wish to request to be analyzed objections because we wanted to hear the reading that was just made, Mr. President. We thank you. Thank you very much. Can you explain clearly? I don't understand exactly what you are requesting. Can you explain what you are requesting? Do you want that this afternoon you're given time to prepare maybe your arguments? What are you asking exactly? Say exactly what you want the court to do for you. Thank you very much. We want enough time, Mr. President, enough time after this process today, enough time to prepare our objections and formulate them. So we don't know whether, given the urgency of this matter, whether you will set a specific deadline for us to present these objections, because maybe you need those objections in order to set the date. You know, the Prosecutor General will need maybe this information to set the date for the next process or the next stage in the process. This is what I was requesting, Mr. President. Thank you very much. Mr. Rusesabagina, do you have any thing that you wish to say about this? Thank you, Mr. President. What the lawyer had just said, I agree with that, and in fact, we had already agreed on what he just said, including my co-accuser. Now, prosecution, you have had the party. Can you please respond? Thank you, Mr. President. Thank you, lawyers, judges, and lawyers. Having heard this issue that has just been raised about objections and what had just been said about the decision that was read, we've had Mr. Rusesabagina, his co-accused, and their legal team, and this is our position. As the SMS system shows, there is already a set of objections that were presented, and we have all read them. We have all have access to them. They are already in the system, and the position of the prosecution is already known as regards these particular objections. It is already known. Therefore, I do not think they should be allowed to proceed as they suggested or requested. The second thing we might say to explain the matter is this. They say that there had not been previous objections. It is not a fact, because some of the accused have already made objections. Can I ask you, you know, there is Sanzomukire Felicien, Nyaneza Rusesabagina, who have asked for the floor, so you may conclude on that. The President says, well, they are saying that they were not aware of objections, or rather the decision and how it's going to be formulated, and they needed to hear the reading they had just made so that they can adjust their objections. This is what they are explaining. I'm sure, I don't know if I explained it properly. Yes, what we can add is that they can add to the objections that they have already written or presented. They can add, you know, they presented their arguments, they can maybe add, but that is normal, but it doesn't mean that the process should stop or that the court should adjourn. Mr. President, what I like to add to that is that I would like it to put on record that we have various accused here. Rusesabagina is one of them, and at any point, objections may always be raised. That is a right. But as my colleague had just said, as regards the decisions, we should know or note that Rusesabagina is not the only accused who has raised objections. Sanzubukire, Nizeyimana have also raised objections, and they are already in the system. They were taken up. Another point, there has been, we have already noted that there are 3 objections that have already been made. They had been presented and decided. So you can always make a note to the plaidoirie.
Inzitizi zamaze kugaragazwa zirimo
And you can make not the plaidoirie that is a final argument, like a final argument, but the objections are already in the systems. As regards the way he was, the manner in which he was arrested, the deprivation of rights that he has claimed, all these issues were raised, and they have been answered. Various objections from the part of him and Kwakis were raised, they were answered, and they were taken up. If there are any additional ones, of course they have a right to continue presenting the objections, but the ones that I mentioned have already been dealt with, and the court shall continue. Thank you very much. Mr. Gatera, what is your reaction to that? Because it has been said that the court cannot be adjourned because the objections that you mentioned have already been presented and they have already been reacted to. Thank you. Thank you.
hari imyanzuro yari yaratanzwe koko, Monsieur le Président.
Thank you, Mr. President. It is true that a number of objections were raised previously, but from our side, we had not taken them as or presented them as part of
ni yindi
So, what we want to present now is not something that was already within the system. It isn't, because these are objections that we have but we have not as yet written them out as written conclusions or as a brief. They're not as yet a brief. So and this is what we want to request to be allowed to do. Now, it has just been said that we can always have an additional note, an additional brief.
ubushize iriya nzitizi twari twaratanze
Or further arguments. Well, I think maybe this issue of written arguments has yet to be settled, because a number of other issues are raised within the pre-trial or the past process, let's say, because there were a number of pieces of evidence that were not yet properly prepared, and so therefore we wish to be allowed to have a written brief that we shall present in writing to the prosecution. The reason being that we do not wish the prosecution to claim that they were surprised And I think in the, if we base ourselves on the right to contradiction or, fairness, it will be good that such a written brief is presented from our side so that so that everything is done properly, so that we present this brief, and then we will, then you will decide. Well, says the President, Mr. Gatera, there is something we don't understand. Can you help us, please? You presented objections. They were written objections. I don't mean the ones, Mr. President, I don't mean the ones that you have already decided on. We have heard that because there have already been objections that were decided on. Are you saying that you need more time or to present your objections or your brief, and then we come and decided on it? What? I don't understand what you mean. Yes, Mr. President, it is a fact that objections were made. And we have no right to question this because it is your... No, I'm saying, what do you want? Please, because you've already given objections. You say you are not questioning these previous objections that were answered. You said you now have other objections that you want to write, to present in a written brief. What do you want? Because do you want to go back on the objection that were answered? Do you want to add on them? Or you want to prepare something else? Well, Mr. President, what we are asking or requesting is that the objection that we plan to present, which may have a relation with the previously presented objections, is a fact, but still, Mr. President, it is not exactly what you have already ruled on. Because you see, the way that Rusesabagina say he may have been impeded in his preparation for his defense, this is why we want to write a brief and send it to the court. Very well, says the President. Now, let me ask you a question so that everything is clear. From your side, do you think that the objections, if you don't give those objections, the previous ones that you were given wouldn't suffice? Even if they are related, that's like a second question. Even if they are related, do you think it's something that if you don't put it forward, it would impede the process? Or do you think if these objections that you intend to raise, can they not come at a later date during your defense? Well, Mr. President, what is basic and fundamental is that what we want to raise as objections are related. They are in a way a follow-up to the previous objections. Actually, Mr. President, what we want is to reformulate, because what the prosecution has called objections, in our view, it was merely something to facilitate and smoothen the preparation of the court case. And therefore, now what we want to present in this brief that we propose is objections that are more fundamental, because what we say, so fundamental that we cannot go ahead with what had been previously ruled upon if we don't give these objections. Thank you.
Well,
we don't understand you. We don't. Because you have submitted a number of documents in English. We have read them. We have understood them, what you've already presented. There are many issues about Rusesabagina's rights that you were saying had been violated. Now, my question, do you want these issues to be raised today or do you not? No, just a moment. Before you answer, says the chair, a further question. So we don't want to go into the substance of what you are saying. We're just saying what you called motion. You know, you had motion 1, motion 2, you know, in English, and you raised a number of issues about rights that were not respected. And you even concluded by asking Rusesabagina to be released. These are not matters. Are you saying that these matters cannot be raised during the process of the court? Or what do you want to present them separately? Mr. President, honorable judges, we cannot present these objections during the trial today because we need to review what has been said, the decisions that were, or rather the rulings that were made. So in other words, we want to review our position, our objections in light of the ruling that was given this morning. Because there are consequences to this, the reading that was made, the ruling that was read this morning. Well, sorry. Yeah, just a moment, please. I think we need to consult. We give you the floor whenever you ask for it.
iburanisha ryarisubukuwe ubushinjacyaha twabonaga
twashakaga.
Thank you, Mr. President. Actually, there are two issues that we wanted to come back to. First, when we adjourned last time, the court recalled that all those who want to present objection should do so. Mr. Gashabana and his client do not explain why they didn't prepare anything. Well, you know, they've already said that the ruling that was read brought new issues, and they couldn't do anything before it because there were other issues that they wanted to understand. So this is the explanation they've already given. And now that they've heard it, they want to reformulate the objection. Yes, sir. Yes, Mr. President. This is what we understood exactly. Now, the ruling was about jurisdiction, whether this court has jurisdiction or does not. If it is decided that they have jurisdiction, the process then, of course, will continue. The trial, we will go into trial. This is what we all understood. Second, in case the court does not have jurisdiction, there was, of course, there was no more else to say, nothing else to say. Now, if it is decided that it's ruled that the court has this jurisdiction, then of course the whole process of the trial goes on. Second point, we cannot, remain in the abstract. You say there are objections. What objections? They are on what point? Do they contradict the objection that you've already put into the system? Because for the court to decide, we need to understand that the objection we want to raise or the arguments that we want to formulate are new and different from what is already there in the system. You cannot be abstract. You have to explain to the court and all the parties in what way these objections impede impedes the examination of the issues that you've already raised and are already in the system. You understand? So, for us as a prosecution, we don't see the relationship between these objections that you're talking about and the ones that you have already put through the system. So please, Rusesabagina and his defense team, please, can you explain so that we understand clearly in what way the objections we want to raise do impede or do not allow the examination of those that you have already presented in the system. Second, you are the ones who set the tone, as it were. You asked the questions or you raised objections. And then you said that there was an issue of jurisdiction. But you had already described the whole process, which we could not examine a set of a whole slew of objections. We could not be resolved before the jurisdiction has decided. You understand? So you cannot just now come and say, oh no, there are other things, objections, abstract. What are those objections to see how they fit in and how they impede the examinations of what you've already put in the system? You understand? So, Mr. President, I think this is the issue. We have objections already in the system. We have issues that have raised already in the system. Is it that the objection they want to raise now, or the arguments they want to raise to present now, if they are not raised, would impede the process of reviewing what is already in the system? Well, this question was asked, previously raised, unless he's allowed to write a new brief with these fresh arguments. So, sir, these questions have been already answered, or rather asked. Thank you. Now, why I'm using the word abstract is because without his explaining what is the relationship between what he now wants to raise and what he has already raised, I want to see the relationship. Is it that the previous formulated objections are not clear? Does he want to clarify? Does he want to add to? Because we shall, the court cannot decide unless we know why. No, don't go into the issue because it's up to the court to decide. Don't mention any decision. Have you concluded? Does your friend ask for the floor?
Thank you, Mr. President. A few things we want to add about this point. It's been mentioned over and over again that Rusesabagina and his lawyers are the ones who entered objections in the system. It's not just one argument. There are three arguments in the system that were introduced at different stages. Mr. Gashawana, the lawyer, says that what the prosecution calls objections, that they see that means to allow the defense to prepare their case. But that's not true, Mr. President. Those three arguments in the system are not about the means. We're aware of that. There's a motion from 12th February, three motions from, one is from February. There's another motion on 20th January 2020, though I think it's 2021. So we've seen those motions and analyzed them. So those are the motions he's been talking about. So I just wanted to mention the fact that we're aware of those. Thank you, Your Honor. As we see in this dossier, the prosecution has responded to those objections. And for them to say that they want to suspend the proceedings today, for them to have time to prepare more, we think it's not a good reason to stop the proceedings. So let's look at what the law provides for. Article 127 and the law about criminal cases stipulates how proceedings should be carried out. In Section 5, it says that the court analyzes objections that have not been analyzed, and they rule upon those, and except others that can be introduced at any step of the process. Mr. President, we don't think the accused have the right to be accused and then the next day they come to court and refuse for the proceedings to be conducted just to go and bring in more objections. This criminal procedure is taking place. Is the second time we meet here. We were here on the 16th, and those objections had been introduced already. So it's not understandable that after all this time, is there a law? They've never mentioned any law anyway that supports the saying that they need more time to go back and bring more objections. This has taken time, and then they say we don't want to make pleadings on the objections that we gave in the last time. So Mr. Rusesabagina and his co-accused, we want them to put this in writing and to say that the first objections they introduced are now irrelevant. If they are irrelevant, then we can understand that and welcome more objections. But it's not just him. There are other people who have introduced objections. But their right should not be overwritten by Mr. Rusesabagina's rights. Well, he said he's speaking for himself. He said he was not speaking for others. He said this clearly. Thank you. Maitre Gatera, you want to take the floor? You hear what the prosecution is saying. Is there a relation between the first objections and what you say today? That there's no law supporting what you're saying, that you're saying all you say in a very abstract manner. What do you say about that? Your Honor, what we are saying, we want to explain that what the prosecution says, they have no right to stop us. To stop us from introducing objections. They have no right. They have no right to stop us from filing a motion. They have no right to make us prove the relationship between today's motion and the last motions. We've explained that the previous motions are related to objections, but those are not objections. Until now, until we give you our own arguments, the motion, the very motion we will be giving, is that very motion we want to go back and prepare clearly, and then we file it in a written form. We don't even need 1 week. Give us that possibility to go back and prepare that motion. As a way to refine what we want to file as a motion, Your Honor. But the question is, why haven't you done this? The chamber had said that should it find that it has jurisdiction, then we should go on. I think I've explained this, Mr. President. We gave a motion about jurisdiction. And once you do that, it means that you wait for the court to establish whether or not they have jurisdiction, like you said, to rule on that jurisdiction issue. So once you have filed that motion, and until you know the court's decision, Your Honor, all what you call objections, we had explained those when we requested the court to give Mr. Rusesabagina all the facilities. So we wrote a letter explaining those. So what you wrote before were not motions? Is that how you see it? No, it was in form of objections. Because when we filed a motion about jurisdiction, we could not file any other motion until then. Now, if you're saying that we're not being very clear, that we're abstract, please bear with us, Mr. President. We will give you those arguments as soon as we can, and then the parties will understand that this was important. So the prosecution says, what's the law that supports your request now? So why would the court agree to that request? Are you saying that you just the file before as a motion is irrelevant now? Your Honor, if you look at Article 29 of the Constitution, and about criminal procedures, One guiding principle is about true justice. There's a guiding principle about contradictory principles and about defense rights. Those are general principles. What do they have to do with what we're saying here? So if the prosecution finds that for them it's important to request that a person be tried without respecting, abiding by those principles, Your Honor, I think you're the one who can, you'll be the judge of that. So what the court wants to know is that what do those principles have to do with the motion you want to file? If you're tried, if you go to trial, how are those principles denied, neglected? It would mean that we were not given the right to file the motion in a manner that we want in the interest of our client. So we find that, Your Honor, we're not asking for a month, not even a week. We just need enough time to put this in writing, to explain this clearly. The prosecution has no right to say that we're being obstruct. Let them wait. They will have that motion and they will have the possibility to respond. So please explain this, clarify this. So what do we do with the previous motions you filed? Oh, just objections. You mean, what do you mean exactly? I'm talking about objections that Mr. Rusesabagina, based on what Rusesabagina has experienced as obstacles, as we have explained. And we filed those so that he can have the right to prepare his trial. So you mean that was just information, not motions that the court needs to rule on? That's right, Mr. President. Then the court can please wait until we file a motion, a duly written motion. I think the prosecution wants to. Are you done? Does Mr. Rusesabagina wants to say anything about it? Nothing, Your Honor. Your Honor, let me add this. I'll be brief. Here is what we're asking of the court. It's about every accused right. These are objections. It's a motion we want to file in the context within Mr. Rusesabagina's rights. And I don't see how the prosecution can stop us from enjoying that right which is provided by the laws and the Constitution, all international laws about defense laws, it's our right within the exercising that we need to exercise. We understand that we know how it's done in criminal procedures. Your Honor, what the prosecution says, it's an ordinary law, and we've mentioned the Constitution. Article 106, it's about hierarchy of sources of the law. And we find that even based on only those facts, we deserve the right to respect those principles. Thank you. Thank you. Go ahead, the prosecution. Jean-Pierre, you want to say something? But we need to move a little faster. You've heard the defense. We understand. We understood that, Your Honor, and as it was mentioned, time and again, we need an explicit declaration from defense, from Rusesabagina's defense. On different dates, they've filed 3 motions about different issues that needed to be addressed by the court, including that his identity needs to be corrected. Second, it was about his different rights. He arrived in Rwanda and was brought before this very court. So those 3 motions, he said those are objections. He said it's information he was sharing with the court. He said it was not motions. So, Your Honor, we want to clarify that. With those 3 motions, and the prosecution responded in 29 pages, 29-page document, dealing with each one of those motions. We gave our views on that. The court needs to decide on that. Article 122 of a social
procedure iyo nta cyavuzwe muri procedure penal
about civil cases. It says that if you drop your case, you renounce your right to go to court and your right to have that court tried. We want the court to analyze that. He gave his motions, 3 motions, and we've responded to each one of those. And now he's combining all those issues, saying that he was just an information sharing exercise that he shared with the court. He was just preparing his case. Your Honor, we want the court to ask him, to request him to make an explicit declaration before the court, saying that he's dropping those 3 motions from today and that he will never come back to those from now on until the end of the trial. He should say that explicitly. So, well, we've heard what he said he told the court. He said it was information, it was just obstacles. So it's just information. I think that's what Maitre Gatera said. But you can carry on if you have anything else to add. Thank you, Your Honor. We want to come back to 2 points. One is about that last point, that he should tell the court that it was not motions. He should say that clearly, explicitly, that it was information. But let's remind the court that on 16th February, another issue was raised but was never analyzed because of another objection about jurisdiction and identity of the accused, where he told the court that he wants the court to correct his identity, that he wanted the court to acknowledge that he is a Belgian citizen, not Rwandan citizen. we said that he of the motions that he now calls information. So we want that aspect fully clarified, and the court needs more. Second point is this: it's the time they are requesting to go back and prepare another the motion they want to file. The prosecution does not stop him to go back and do that. We did not say that, and we've mentioned the law that stipulates that. But we do not point that is within one of the conventions signed by Rwanda about International Covenant on Civil and Political Rights, Article 14 and Article 9, and especially on Article 14, paragraph 3b, about the right to have time to prepare your trial, the right, time, and facilities to prepare your trial. Your Honor, we will talk about time here. Maitre Gatera says it's not even a month, maybe a week. What we have an issue with is not days, week, or month, or 3 days, but we are before the court right now. You see, the parties should not request the court to rule upon something that remains abstract. Article 14, about those rights to have time to prepare your trial. Yeah, to prepare one's defense. Your Honor, and based on what was mentioned in their general comment, number 13, they've explained what time means, or the right time given the requests by one of the parties. If we use the very words used in that general comment, it says this: what the within the court, it's not about a week or a month, but they should motivate the court cannot give on due. It's a reasons of a crime, innocence. At no point does it discuss the motions that the accused can file. So that Article 29, when he's though we were talking about criminal procedures, This Article 29 does not contradict Article 127, which is the one that applies to the case being discussed here. So he says the 129 in the Constitution, but he does not mention this to motivate his request to quote an article, but you need to know the content. So this article is about true justice. So from paragraph 1 to 8. So what is the segment? I think so the court has asked him that very question, and you've heard his answer. Maître Gatera, do you want to take the floor, or is it very clear to you?
hari ikibazo ubushinjacyaha bwa
The prosecution has insisted on identity. I think when it comes to identity, the one who gave their identity is Mr. Rusesabagina, and it was about citizenship. The court asked him, is the identity as said here, is it correct? He said the court got it wrong on the citizenship. The registrar took note of that. Doing that, it raised a debate. But the court itself said that what's being tried here, or other things, that the issue is not about citizenship. It's not about trying the case in itself. The registrar limited his note to citizenship of the accused, period. If the prosecution found just a self-declared Belgian, it's not to be judged by you, Your Honor. That citizenship issue in other mechanisms. So the prosecution says this: what Rusesabagina asked to be corrected about his identity, he said it's not part of the motions that you call information. It's not about citizenship. It's correcting the identity because he said he is a Belgian citizenship. That's right, Your Honor. Mr. Rusesabagina wanted his identity to be corrected, which was done. And if the prosecution has a say on that now, I think there should be another mechanism that should handle that. And it should not be before this court that you're presiding, Your Honor. And you've said that, that's how you said it too. If he says he is a Belgian citizenship, and the prosecution sees otherwise, and live during a court proceeding, then that raises a debate. Now, are we going to deal with that debate before you? When we know the case that was brought before you, I think, Mr. President, that would not be right. So we find that if the prosecution has an issue with that identity about citizenship. And if our client states his citizenship, then that debate should be handled in another setting, not before you. But if it was brought before you, they would fall in that trap of delaying the proceedings, even though they were accusing us of that. So I think, Your Honor, that's how I see this. Both parties do not agree on citizenship, but it can be handled in another setting, in another mechanism, and according to the law. And it's not before you, Your Honor, because when they indicted him, they never say that he has usurped a different citizenship. It's not within the indictment. And, Mr. President, the indictment is the one that guides these proceedings before you. So we should not waste time on that citizenship issue. Moreover, Your Honor, they're saying that we did not, that we're speaking in abstract terms. Your Honor, we told you that we have objections. And we say that within our strategy, that we could not have filed that objection before you had ruled on jurisdiction. You've just ruled on it. And now we're saying that we have objections. All we need is enough time to consult with the client. And this requires enough time to prepare our motion in writing. And we're not doing this just to play games with the prosecution. We're doing this to make sure that our client and the prosecution, that all parties come back before you with something that has been communicated in due form, in a due process. We cannot say, no, just go ahead and keep talking. It's all right. You agree with us that it's all right, as per the Constitution in Article 29. Even though they've mentioned a few points, the most important thing that guides me is the right to true justice. It's the right to that principle that gives us the right to give our arguments. You always remind us of that. So how would it be overlooked now? Your Honor, they just read in international conventions on civil law, Article 9, Article 14. Those principles are the ones similar to those in our Constitution, Article 29. Moreover, even though it was provided for in Constitution, Article 18, Constitution of 2003, it said the defense rights are absolute at all steps and all degrees of the proceedings. The current Constitution has maintained that. And if you bring a position, a note, a document introduced by some person in relation to those articles, Your Honor, that does not stop our request related to that true justice, Your Honor. Therefore, Mr. President, I think what the prosecution says, and by the way, let me remind you that the prosecution started just like us. What they request, I mean, if they said we need time to prepare our arguments, it's their right. I don't see how that would be denied. So they should not deny me the right. They have no power to deny me to do what I need to do. Well, they have the right to respond to what you say. You respond to what they say. They don't decide. They were saying, well, he should say right now, right here and now, that he denounces, he drops the 3 motions. Now, Your Honor, defense rights is at all steps of these proceedings, which means this. If there is an exception that they want to raise, if we do have something to raise, it's at all steps. But we need to remember what the new law says about criminal procedures. We need to keep that in mind, that current law. It's not like back in the day. We know that, Your Honor, but the law says we can do that at any step of the proceedings. So that's what we're requesting. We're not requesting for a long time. We're not aiming to delay the proceedings. What we want is to exercise our right. I think we have heard something new, that you also need time to consult with your client. This is something you hadn't mentioned. And I think that's fundamental, Your Honor, because for me to file that motion in writing, we will have consulted, we will have discussed, and he will have given his blessing to the document. Thank you, Your Honor. Thank you. That point is understood. Now there's another point we need to discuss.
nibyo byari ngombwa ko icyifuzo cya Rusesabagina.
It was important for Rusesabagina's party to say something about this, but this is not just his case. If anybody wants to raise a question, the court is ready to give you the floor. Is there any other person who wants to comment on Rusesabagina's request that has been discussed between defense and the prosecution? Somebody wants to say something. Identify yourself. Maître Mugabo Sharif Yusuf. And who do you represent? Your Honor, I represent Kwitonda André, Akizimana Théogène, and Ndagijimana Jean Chrétien. Let them step forward.
President.
Your Honor, Honorable judges, my clients have this first and foremost interest. It's true justice. And the justice given in the right time. Your Honor, we've heard a debate about laws, and that debate needs to be clarified within the law. Your Honor, if you look at the Article 132 on criminal procedures, Your Honor, it's about what the registrar puts on record. It says this: the registrar records matters of related to proceedings, identity. It also says this, that she also writes down the main words they say, and they sign on it. Your Honor, if I want to mention something about the rights of my clients in this case, it would be a good thing in this Rusesabagina case if they clarify their motion, the nature of that nation. They're not saying that they're going to look for a motion. They say they have the motion that they want to put in writing. So it's within the interests of true justice for them, while they put that in writing, that we have at least an introduction, so to speak, for that motion. So as the court analyzes whether or not to give them more time, then we should also know that if they do that, either the co-accused have an idea on what Rusesabagina is working on, so they can have time to keep preparing their defense. And all is within the interest of true justice, not delayed justice. So that's within, it's their right. That's what I wanted to say briefly. I thank you, Your Honor. I don't see anyone else who wants to comment on what Rusesabagina and his lawyer have mentioned. So allow us to take 10 minutes so we can consult. We'll be back in 10 to 15 minutes. So we'll be back in 15 minutes.
Allo, 1 2, allo, 1 2, 1 2, allo, 1 2. Allo, 1 2, gatandatu babahereho. Allo, 1 2, allo, ngiri kuvuga niyi. Allo, 1 2, allo. Check mic, Jotam. Kirimo, 1 2, allo. Kirimo. 1 2, kirimo. 1 2, kirimo, 1 2, 1 2. Kirimo, 1 2, 1 2. Kirimo, 1 2, kirimo, 1 2, 1 2. 1 2, kirimo. 1 2, kirimo. 1 2, kirimo. 1 2, kirimo. Oya twakase ampli ntacyo niyimbwiragira. 1 2, kirimo. 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 baranyumva se nasaraye nibansubize niba banyumva bwana 1 2 eh
saying that they had not prepared this brief because they didn't know what the court was going to rule, and he requested to consult with his lawyers, and having heard the prosecution saying that Rusesabagina and his defense team have not been specific about what they are requesting to be allowed to do. Therefore, the request for a reasonable delay cannot be decided on because they have not specified the content of having had the prosecution and having had the defense team of Rusesabagina. They were requested to specify the content of their request, but they did not. And therefore, given that Rusesabagina and his team have requested the necessary time to prepare their brief, given that the objections that they had presented are already in the system, it is therefore ruled that for the sake of a fair trial, they should be given the requested time. It was, however, decided that given that there are other parties that have also requested to be allowed to give objection, these also should be allowed to present objections. Thank you. Yes, so you have heard the decision of the court as regards the time that will be decided later on at the conclusion of this session. But so the time element will decide among all parties what is more convenient. Okay, so Mr. Nsanzumuhire and your defense team, please come forward.
mwaza mugerageza guhana intera.
Please wear your masks. There are some of you who have forgotten to wear your mask. Please wear your mask, and we don't be too close together. Don't stand too close together. Are you the defense lawyer? Yes, sir. Go ahead, please. Do present your requests. If you represent both of them, that will save us time. Nsanzumukire Felicien, what is it that you're requesting the court to do for you? Thank you. Please speak closer to the microphone. Thank you, Mr. President. I should like my defense lawyer to explain that matter, Mr. President. Though I think it's better for him to present the issue. Thank you very much. You have the floor, says the chair. Thank you, Mr. President. We would also like for him to sit down because he's weak. Yeah, he may sit. He may sit and just follow the process from your chair where you're sitting. Thank you, Mr. President, honorable judges. Article 125 of the Penal Code, paragraph 13, as well as the articles we raised during the preliminary hearing, in virtue of these articles, and before going into the gist of the issue, we are requesting the court, in its wisdom, to allow Munyaneza Anastase, Nsanzubikire Felicien, to be released or released on bail, or conditionally, rather. Released fully or released conditionally. The court, for example, of course, will not respond before we have fully explained this issue, and we accept that. Mr. President, honorable judges, the articles of law I've just cited, including also other relevant provisions, we have asked, based on that Nsanzubikire and Munyaneza Anastase be tried on the basis of Article 6 of the Penal Code, which might serve as guidance for the procedures. It says that if there is a law, one that applies before the crime, and another one that was adopted after the date of the crime, the latter is the one that follows, provided that it is less stringent than the previous law. So we were saying that Nsanzubikire and Munyaneza, one of them was arrested in 2017, and the other one on 2017, but later in Uvira, South Kivu. So the new law came out in 2018, and they were arrested in 17. So we think we should look at this as to which law should be applicable. But we will not insist on this, we're just reminding you of this fact. Mr. President, before the court, we base our process on the 1963 article, and also the Article 47 of the Penal Code, where it is said that if a person is imprisoned before they are tried, they may request the court to rescind his imprisonment order or to be given provisional release. So before we speak to the substantive matter, I think Article 90 and 91 of this article, or rather of this code, or the Penal Code, should apply. The accused or their lawyer should request, please wear your mask, says the President. Please wear your mask. Yes, so as I was saying, the lawyer, the accused or his or her lawyer may request provisional release depending on the progress of the investigation. And the decision should be taken within 5 days. Once objections have been made as regards provisional imprisonment or provisional release, then the decision should be taken and the conditions of his conditional release be described or set forth. Mr. President, these are the articles that I would like to base my request on, and also the request of Munyaneza and Sanzubukire, my clients, their wishes and requests, and the reasons for that. The two accused are requesting to be released provisionally because from the time they were arrested, they were not difficult. They made no difficulty. They gave all the info, all the data, and even they gave more data, more information that what the investigation had already collected. So they cooperated fully with the court. They have accepted also that they are part of an illegal armed group. They have confessed and accepted this. Can you be slowly, go slowly? I think the registrar is being lost a bit. Please, yes. Begin where you're mentioning those two articles, and please speak slowly and clearly. Thank you, President. What I was saying is that we are basing our request on these two articles because the two accused, in their request to be provisionally released, they say that from the time they were arrested and were brought to justice, they made no difficulties. They cooperated and responded to all the questions that were asked of them, and in fact they volunteered further information to complete and supplement the investigation. So it is also clear, Mr. President, that they no longer need any additional investigation into their case, and in any case, whatever they may be, they will they will present no difficulty or objections or obstacles. They have admitted that they are members of an illegal armed group. They have voluntarily confessed and testified on all points that they were questioned on. Therefore, sir, Article 66, Article 6 of the Penal Code says that if a person is accused, they may be tried without having to be imprisoned. So this is usually what is said. This is a very good principle, and I think we should look into it. There is also Article 88 of the same Penal Code. We are using this article to clarify any misgivings that the court may have, because in this article, all the items that must be respected are listed. 1, you remain in that district. If they are released, they will remain in the district. Second, not to go beyond the designated area without permission. They are ready to comply with that. Third, there are areas where they are not supposed to live or move to or travel to. They are ready for that. Fourth, they will submit to electronic surveillance. That is no problem for them. In fact, they think that may help them if they are properly surveyed. So these are the articles of the law, sir, Mr. President. And we think that since they are ready to obey any conditions of that under that conditional release, we request for them to be released. As regards Sazubuchire, Mr. President, there is something specific about him. He said that he's weak, he's ill, he cannot stand a long time. He has spelling or fainting spells, and you allowed him to sit, Mr. President. So since he was allowed to remain sitting or remain seated, therefore that is also an argument in favor of his release, because his health, he is ill. The doctors have found him to be quite ill. And therefore, Mr. President, that is also an argument. He also said he used to weigh 80 kilos almost. And as you see him, I don't think he can make even 40 kilos. But that is the point we want to insist on or to put forward, is that he is in ill health. And therefore, the court, bearing in mind his ill health, should release him so that he can continue his trial, but while he is outside the detention facility. Now, if it is not possible, to release him, the court should order the prison to give him special care, to put him on the list of people who need and are allowed special medical care and also special diet, a special diet. Because if in those cases. But it was eventually the same grounds that I cited. Why? Because we were given brought him what I appreciate them look at they did. He was much in a much better shape. So he's given the state and the doctor but I hasten to has been responded to. It is true that it's true. It's only the case that is reported and intuitu persone as these presidents show nothing unto one or other that this had been raised. We come to the trial. What your person who is concerned and as a ground to extradition case. Let me just read what I have to make sense very much. So let me And then we brought Rwanda. That is also an issue. We don't know. Should be looked into, and there is an agreement. That extradition agreement has provision. So there are, an of the crime, the really well, look, please. Are you saying don't go into these other issues? Whether they well, we understand. So what's the ruling that is that then from that Mr. President was saying Article 145 provisional release so that they can be tried. Mr. President, to conclude, in their case, it can be clarified, but that wouldn't be released provisionally. You say something, or the lawyer has
penal code will be what we think about a request by Munyanez based on our position on the special request in with this with the part about what's said was not respected. Your accused a law that came after the code November 2nd, 2013. That's the law that should be the basis for the examination of that's the law that should be the basis for the examination of this is an article and in clarifies and defines what extradition means. The law says this: extraditing the next paragraphs are about procedures that are followed in that that claim is irrelevant. Extradition of suspects they have no justice. Countries can use their powers and their laws to transfer those individuals to their countries of origin. Like we said, extradition is a mechanism through which to every country. That what we want. Should be released. Said this. They said these are individuals, not groups. They said there's a difference. Well, let me interrupt you a little bit. You gave an example where they extradited. Tell us what happened. Thank you, Your Honor. Oh, maybe you're going to come to that. Individual to be moved from one country to their country of origin. But this is leading to us explaining that it was not extradition, but we're going to explain how as we've said earlier, rather. So these are physical individuals, and examining the merits of the case in depth, but how they arrived in Rwanda different from the groups. Individuals before you, Munyane's purpose was to will, will, all the time. You will have all the time. Rwanda had requested for them to be extradited. There was no extradition request for these individuals. But in Article 2 of the extradition law, these individuals would have been requested by Rwanda, but they arrived here because of their membership to those armed groups. We've clarified that in our arguments. They belonged to armed groups in the eastern Congo. They were the Security Council resolutions were adopted, and once the FDLR and other armed groups in the eastern Congo posed a big threat to Rwanda and Congo's security and the security of the region as a whole, the UN Security Council adopted different resolutions that we will not mention, but clarifying that measures needed to be adopted to fight and disarm those armed groups
gusubiza abayirimo mu buzima busanzwe
and reintegrate those armed elements back to their countries of origin and be helped, assisted to return to civilian life through DDR. So the countries had the responsibility to disarm those armed groups and to integrate those former combatants into civilian life back in their countries of origin. We gave different arguments. We gave 1925 UN resolution of 28 May 2010, paragraph 12. That resolution gave MONUSCO the mandate, within its second mandate, to support activities within the Congo to disarm those armed groups investigation team. And when you look at where they were arrested and the road they traveled all the way to Rwanda, it's obvious that if they were released, because they didn't come here from their own will, on their own, if they are released provisionally, they would go back to the armed groups that they belong to. Today, those armed groups are still active in Eastern Congo. So if these individuals were released, it would be an opportunity for them to go back where they came from. Remember, they did not come here freely. You know, those groups have the intent to keep attacking Rwanda. So they have the right to request for provisional release, but we believe they should not be granted that request because they accept the crimes they committed. We know how they were arrested. We know what they intended to do. We know what their colleagues are still doing. And about the provisional release request, because it's a principle that a suspect can be prosecuted out of prison when they're out of prison. We agree with that. But Nsanzubukire Felicien and Munyaneza, who are mentioning this principle, they pretend to not know that this law, that principle, has exceptions. Because within this principle, the law says this: the suspect can be prosecuted while in jail when there are serious reasons, serious crimes for which is accused of having committed, which can be punished for more than 2 years in jail. So that's principle. It's a principle that has exceptions too. It's not just for the Rwandan law, it's per the international law too, including international human rights and civil laws, because provisional release has exceptions. Your Honor, and about Nsanzubukire and Munyaneza, let's reiterate the fact that they committed premeditated crimes, including belonging to an illegal armed group and belonging to a terrorist organization. And these crimes are punishable by more than 7 years in jail, 7 to 10 years, using 459th article of the Penal Code of 2012. Belonging to terrorist organizations, you get from 15 to 20 years in jail, as per the law 503 of the 2012 law. Now, therefore, Your Honor, given that there are serious reasons, these are more than serious, because they admit what they did. They admit that they belonged to illegal armed groups, though they deny that they belong to terrorist organizations. And the crimes they admit are punishable with more than 7 years in jail. And we've said that if you look at how they were arrested and the whole context, you cannot release them provisionally because of those reasons we've put forward. Your Honor, Nsanzubukire Felicien requests to be provisionally released for health reasons. They say that decision should be based on the court's rules that he mentioned, and also that decision should be based on and because of his health status, he should be released because it was done for other individuals too. The prosecution finds that all his reasons, so some of the cases were from TGI and others RDPA, and others RP, TGI, it means that those cases were tried by secondary courts. Your Honor, such trials cannot be cannot guide the High Court Chamber of International and Cross-Border Crimes, because this is a higher court, so they cannot be guided by a lower court. Your Honor, let's please allow us to add this. All those trials that he's mentioned, they've mentioned in their arguments. If you analyze those cases, all suspects had clear known identity and an address in Rwanda. It was possible to find them at their addresses when needed. Nobody knows where you could find Sanzobukire, as you have in the dossier, with his identity. Before he was arrested, he resided in Congo's forests as a member of CNRD armed group, and he was arrested on his way to represent his armed group in Burundi. He cannot say that he's in the same situation as those who were released provisionally. Those ones, they had known addresses. You could find them when you needed them. This one was a member of an armed group and he was arrested on his way to represent his organization in Burundi. We know where he would go straight out of prison, whether in the Congo or other countries. Moreover, Your Honor, well, those cases they've mentioned, if you look at the crimes committed by the suspects in those other cases, one of the cases with Kanengwa Angelique, it was about embezzlement of funds. Second case with Sebagabo, it was about the other types of misuse of funds, which is different from Sanzobukire, accused of very serious crimes belonging to an illegal armed group and a terrorist organization, which organization was also only intended to kill and destroy, as we've seen in the indictment. That difference, Your Honor, shows that Mr. Sanzobukire cannot be considered like the case of Kanengwa, Sebagabo, Mukanda, Isenga, who were released provisionally. They had known addresses and they were accused of less serious crimes. If you look at the crimes that Sanzobukire is accused of having committed. Your Honor, Sanzobukire said that if he should be released provisionally because of the part he played, major role he played in, because they say he was 80 kilograms and today he's less than 40, and they say that if he's released provisionally, he could seek medical care and nutritional care. They also said that it would prevent for him to die before the case, the trial, which would be a loss for justice in general. Your Honor, the prosecution finds that, but maybe you can his appearance does not prove a lot. There's no medical certificate that proves what he claims. But even if you look at him physically, it's not a good reason to release Sanzobukire, because his being sick is something that happens to other suspects in jails. Even his jail, he's not the one who's more seriously sick if you compare him with other detainees. The prosecution finds that whether as per Rwandan or international law, nowhere does the law provide that sickness to some degree justifies release when there is a good, serious reason to keep him in jail. We'll give you an example. As per United Nations Mandela rules, it's UN Odyssey, minimum rules for treatment of prisoners. These rules, rule number 24.1, this is how it reads. The provision of health care
is a state responsibility. Prisoners should enjoy the same standard of health care that are available in the community and should have access to necessary health care services free of charge without discrimination on grounds of their legal status.
So it means then that the prisoner should be given medical care not lesser than what ordinary citizens are given. So if he's treated in hospital, in a prison, that is what is recommended. Now, these UN recommendations or rules, rather, are followed, and in fact, Article 39 on prison administration explains what prisons should have health-wise or healthcare-wise. So all hospitals have to have a doctor. All prisoners have a right to access medical care just like any other citizen, just like it. And hospitals where special care is needed should also transfer that person for that special care. Transvukire is being looked after medically. In fact, you did admit, the lawyer did admit that he has improved. He has been cared for and his state of health has improved. Of course, one hopes to keep improving. Second, in this same case, Rusesabagina has received medical care. Even he went even to medical reference or reference hospitals. He was transferred. No, please keep to the case. No, yes, sir. But I was just saying that any prisoner is hospital access medical care just the same as any other citizen. All right. So, sir, if a prisoner is treated just like any other person, and therefore that there cannot be a reason for his release, because he can even receive very specialized health care, as I've just said in the other case. Now, his co-accused, Nyaneza, what they have shown, their lawyer has shown as the reasons or the motives for their provisional release, or the release of one of them, we do not find that the court should, based on these arguments, release this person because they are unfounded. Thank you. Thank you. I think there are nobody else wants to take the floor. Oh, you do? You do? Come forward. If you want to take the floor, come forward. And because we're moving close to the closure.
hari icyo mushaka gusubiza ku byo bimaze kuvugwa?
Do you have an answer to what prosecution has said? Yes, sir. Very briefly. Yes, go ahead, but please be brief. Thank you, sir. Thank you, honorable judges. The objections were submitted for examination in on behalf of our clients. Yes, that has been said. Just speak to the decision, to the proposal. Well, it was said that these people were repatriated. That's how they came to Rwanda. And well, repatriation, well, it's for refugees. And it's not the same thing as extradition. So we were not happy with the way they were, with the explanation that was given as to how they were brought back to Rwanda. A second point, Mr. President, in the preliminaries we said that there were many people who have been in terrorist groups. They were brought back, they were not tried, and they were in exactly the same situation, but they were reintegrated and not tried. And this is why we wanted to know how they had been brought back. A third point, Mr. President, is the matter of which law should apply. I know we are in preliminary hearings, but we want to recommend that when we come to the actual hearing, this issue should be raised. But why are you raising this issue? Is it related to your request for release? No, I was saying, sir, that in the preliminary trial, you are given opportunity to explain how you want the court, or the case rather, to be tried, or which direction should the trial go. This is why I'm adding all these issues. It is true that this is not the issue that will come into the matters of the trial, is true, so maybe I better drop that and come back to this issue. The crimes that they are accused of are very serious crimes. But seriousness of the crime does not remove from the other provisions of the law. No, it does not say that the more serious your crime, the less welcome your other requests. It doesn't. No. Of course, there are interpretations of the law that can be understood differently, but I think jurisprudence or the precedent should apply. Whether the case was tried at a lower court or a higher court, Even the Supreme Court can take a leaf from a law court. There is no law that says that if a law court has decided a case in certain way, therefore the Supreme Court cannot base its procedure on that law court. No, it can't. So then, sir, there is something else. I think there was a word that we used that, not a word, but it was saying that there are other sick prisoners. Prisons have sick people. Well, it's true. You can be sick anytime. But if you are before a court and the law admits you're presenting your case and asking for provisional release, that should be looked at on its own merit. You see, I gave an example. Sans Mukire, I said, weight 80, yes, the kilos, you've already said it. Please don't repeat yourself. Thank you. So this is what I wanted to say. And as a reaction to what the prosecution has said, and in defense of our client, of my clients, my two clients, so that one of them, the request on his behalf be favorably considered by the court. Thank you, Mr. President. Thank you, lawyer. Mianeza, do you want to add anything? Mr. President, yes, Mianeza. Thank you very much, sir. Presiding judge, honorable judges. As regards the way we were brought to this country, as the lawyer had just said, I don't think the word repatriation is the correct one. I've admitted and said we come from armed groups that we're members of, and as it was also said, DDRR is the usual way you leave such groups to be rehabilitated and reinserted or reintegrated. So we should normally have gone through MONUSCO if it was a DDR. We didn't go through MONUSCO, or rather the UN system. We came through other ways, let's say. And the fear that we may, if we are released provisionally, we may rejoin the groups. Well, I don't think that there is a risk of that, because the security forces in these countries are competent, and that will surely not happen. Therefore, I think the court should look at this request favorably. My lawyer has said it, and therefore I think you should consider this request. The fact that we didn't come of our free will, it doesn't mean that we will necessarily, if we release, run back to our armed groups. Because there are many others who were also brought by force, and they were not even taken to court, but they were released into normal life through training and education process. And they didn't go back. They didn't go back to their terrorist groups. Therefore, there is no reason for us to conclude that we will rejoin our groups. Thank you. Thank you, sir. Thank you. Nsanzu Mahire. No, just a moment. Just a moment. Nsanzu Mahire. And no, if you have nothing, yes, okay, you have nothing to say. Fine. So I think now, with your, if you allow us to consult with my colleagues for a brief while. Objections by Munyaneza and Nsanzumukire will be taken together with the others about Rusesabagina. But as you know, the rule is that they should be examined within 5 days. So Wednesday at 11 in the morning. Wednesday at 11 in the morning. So, but you, Rusesabagina and his lawyer and the other lawyers will also have an opportunity to respond, or rather to react to that. So on Wednesday at 11, we will give the ruling, but meanwhile, please, these, you said you need a short time to write your brief. So please present it in time for us to be able to have the trial. Do you object to this timetable? Last time, you gave your brief. Mr. Gatera, please. You gave your brief at 22 hours. You know, it is too late. So please, if you must submit your briefs, please submit them during office hours. A deadline means office hours. Some respected that, others didn't. Were overshot the timetable. The following day, that's when they gave us. I won't cite the name. But please, if you are given a deadline that you have accepted, agreed to, respect it. So, do you have any reaction to that timetable? So please give your briefs on Tuesday, so that on Wednesday at 11 we convene. Rusesabagina, yourself, or your lawyer, or any other person to react to that proposal. Mr. Gatera, do you agree with that timetable, or do you have any problems with that?
Oh,
I beg your pardon. There is something I had forgotten, so that you can answer together. So you're always citing cases in Belgium, case number this in America, the UK. I don't mean you, Mr. Gatera, alone. I think when you cite these cases, bring them to the court. If you are citing, so and so versus so and so, you don't just give a reference number. It's not enough. If you say, well, this is a case, this is so and so versus so and so, and then you put it in the system. You can just cite that. It's like you say, oh, the other day some court said this. No. It's not useful for us, and it's not useful for you. It does not advance your case. So all these lawyers, you lawyers and advocates should know that. If you bring up a case, you have to present it so that it can be consulted. So put it in the system, please. Thank you. Mr. Gatera, you have no problem with that timetable. Thank you. Mr. Rusesabagina, any problem? No problem, sir. No, none at all. Prosecutor, do you agree or have any issue?
Monsieur le Président, banyakubahwa abacamanza, ubushinjacyaha n'ubundi twari twiteguye kuburana uyu munsi.
Mr. President, we have no problem with that timetable. We will be available on Wednesday and Friday, but let us request that those who have objections should present them. All those who have objections, the accused people should also give their brief. As Rusesabagina, you sent a brief about your objections. That is correct, but the others as well. Thank you. I was going to have that on my agenda as well. I noted that even up to yesterday, there were some who had not given their brief. So really, please, we have to respect these rules because they are very important. Mr. Gatera, you went off before we finished this issue. So, have you given your brief on substantial matters? Because, as you saw, we have facilitated. Normally, you have deadlines, and if you overshow, you don't respect the deadline, your submission is not accepted. But we have been very lenient. But even with this leniency, there are some people, some of the lawyers who still very lax. No, sir, we haven't yet finalized our brief on the substantive issues. And it is not, please don't think it's anything to do with contempt of court. We did submit a brief on
tazitabwaho kuko kugera uyu munsi
we encountered some obstacles that we need to deal with because Rusesabagina has not been facilitated in his preparation of his defense. There are obstacles to the proper preparation of his defense. So we want to work on this so he's beginning all these facilities. And but is that? I mean, can't you do a brief without that? Well, I have here the registrar. We talk all the time, and I'm always calling. I know he calls you. He discusses with you. Sometimes you have even, they invite you for a conference. Where are the objections, or rather the obstacles that you are mentioning? I thought they were resolved. The way you preferred your preparations and so on. What the lawyer said? What you say, sir? Well, none of those were resolved. Okay, fine. So please, you go into that. I understand, but these are This is separate from the brief. Mr. You know, sir, Mr. Rusesabagina has a very serious problem. And I think we presented it in the brief when we explained all the impediments. We go to prison, we go back to the prison. They receive us, they give us an office where we can talk and work. And then I was able to present the indictment to him in that way, and I made specific efforts for him to find some of the evidence that are in the mentioned in the indictment. But you see, the problem is that as soon as I have my back turned, things change in the sense that they confiscate all the papers and dossiers that I gave him. And I think we've mentioned this. So this is an impediment, and it is serious. Also, whenever I take to him, whatever I take to him is the things that I've already put in the system. I don't take him any paper or any evidence or any document that is not in the system. Okay, now look, says the chair. If you think you can't, if you think that timetable doesn't work for you, just say it doesn't work, because now, right now, we want everything to be done properly. I told you that we even have a roadmap so that everything was. So this is the problem. Now, at his prison, he cannot access the internet and get into the system. No. No, he gets documents. I can show them to him. They treat me well, and I can show him everything. But when I leave the papers to him, the prison authorities confiscate them. So please, we need your assistance so that he can keep these papers and be in a position to prepare his case, so that he can also have access to the system, to the documents in the system. Okay. Why are his papers confiscated? No. But in any case, I just want you to explain briefly. You'll come back to this issue. Right now, I want to speak to the date. No, Mr. Chairman, when I'm with him, Mr. President, when I'm with my client, they're fine. Everything is given to me, everything. But as soon as I leave him something, they confiscate them. Why, Mr. Sabagina, why haven't you spoken to the registrar about that? You didn't say that. Thank you, says Mr. Sabagina. Honorable judges, I don't really speak to the registrar so very often. I think it was only once, and in fact, we went to the office of a lawyer, and we spoke with the registrar. So the registrar spoke to me, yes, but I don't think he spoke to me a second any other time. As the lawyer has said, it happens frequently that they give me files and they are confiscated. For example, I went back to prison with a lot of documents that I was going to read on the 21st December. Those documents were taken from me, but I got a number of them on the 2nd of January only. On the 23rd, I also had another set of documents. They took them, but they brought them back to me only in January, after 3 weeks. What do you mean by the documents you have taken and they are taken away? No, like when I meet my lawyer, he gives me documents, and then I go back to my cell, and then these are confiscated. I have a file that has so many annexes, 1,347 annexes. If I have no access to the system, I cannot access these documents. Therefore, I cannot go to the legal office in the prison, except maybe if they give me a job there and I'm allowed to spend a week there, 24, or even a month, you see. And I'm not the only one in prison, the library is a very busy place. And so I think we're going to do this write-up, put all these issues in the paper, but you should know that I cannot enter back myself with any documents. I cannot, therefore, prepare. For example, even the plea or any document, my defense, I cannot take it to my room. So now what can I say that I have that is really mine? So we're going to say all these issues. And what you're talking about documents? What documents are you talking about? You say that there's something you wrote and you remove it from the system. Well, this is part of the problem also.
Monsieur le Président,
Oui, Maître Gatera.
Go ahead, Maître Gatera. You've asked us why Mr. Rusesabagina was not able to provide his arguments. We've expressed the obstacles we came across. We've said that anything that he can use to prepare his defense is systematically confiscated. So how do you put in writing all the arguments you've provided us with? You've introduced a note recently. How come that very argument is the one that you can't get time to prepare? About those documents, especially the one he's talking about, he's the one who is supposed to prepare it. But we need to consult. It's in that context that it's necessary for me to give him the required documents. But legally, all this has consequences. The exchange of documents between a lawyer and their client is something that needs to be confidential. That's the law. I'm not going to go into that, Your Honor. But we would like to request for him to be facilitated so he can prepare his defense. Does the prosecution know anything about that? Are you done? Because we wanted to know why you're not giving us your arguments. You have clarified your obstacles. I'm happy that we've expressed our concern, or the obstacles. Thank you, Your Honor. Your Honor. We want to hear what you say about the reasons, the obstacles they have as they try to prepare their arguments. That's the only point we want you to talk about right now. Do you have any information about that? Thank you, Your Honor. Honorable judges. We want to share information about that issue. As we've said earlier today, the prosecution had prepared a response to their 3 motions filed by Mr. Rusesabagina in his defense. And today, we realize that what they've just expressed here is included in those 3 motions. So we came here ready to share information about those 3 motions and to share the evidence we have about those 3 motions. But like you've seen, you've heard, they say it's no longer an obstacle, but it's information. It's not a motion, it's information they're sharing with the court. But now they say there's an obstacle that will need to be addressed. But now, is it still that's information? They said it's information they're sharing with the court. But you are the ones who have mentioned this. Why don't you give us your arguments? They said they have shared information. Do you have any information about the obstacles they've just raised? He says his documents are confiscated. Do you know anything about that? But as information, like you say, like they said, they didn't file any motions. It was information. Well, and they said we should consider that as information sharing. For the prosecution, as you've clarified, if they can explain other issues and file that information within the system, they know what they're accused of and they are able to respond. Honestly, we believe that they can file an argument without any problem. There's no obstacle. If there were an obstacle, they should clarify it. It's their right. They have the right to know what they are accused of so they can prepare their own defense. That's our position as the prosecution. Your Honor, if you take one fact and call it 3 names, it doesn't change the nature of the fact, because those facts are facts. You cannot change them. If it started as motions and then it evolved into information and then it becomes obstacle, it doesn't change the nature of the fact. The court it relies on acts and evidence because information has nothing to do with it. Look, what they are saying is this. They say they need to be facilitated to prepare their defense. They want the court to ensure that they can prepare their defense. It's about that, preparing their defense. That's what their lawyer said. Is it true or not? That's another story. But what do you know about that? Your Honor, they had said that there was a human right issue within the different motions they've filed, and the prosecution gave its position. It's in writing. Now they say we can't give arguments because there are obstacles that we don't find really to be arguments. What they say, they have information. They should not be sharing information here. They should be sharing it to the Rwanda Broadcasting Agency. They are the ones in charge of news and information. Article 94 of the criminal procedure, we know that the law applies to everyone, not just Rusesabagina. It applies to the prosecution, everybody, from Matakamba to Rusesabagina. Therefore, Article 94 that says that defense arguments are filed within 30 days from the indictment, and now it's been more than 100 days. But he's saying that there are obstacles to them preparing their arguments. But he has refused to make pleadings on that, even though he says it's a major obstacle. So I think these are strategies to delay this trial, and I think the court should take measures against that. Thank you very much. Thank you. Maitre Gatera, is there anything else? Aren't we done? We told you the reasons why we didn't respond to the arguments. The prosecution seems to want us to do what orients how we will argue. However, your question was clear. Why didn't you file your arguments on time? We've just explained that, Your Honor. We've also requested that based on the powers conferred to you by the law to help us deal with that issue. The prosecution, that's a party just like us. They should not be on the defensive like an individual who wants to delay, to obstruct the smooth running of these proceedings. Normally, we ought to be coming together and agree on some of the elements in this case. But that systematic refusal to listen to us is a problem, Your Honor. But they just say to prepare your defense. But are they orienting how we will argue our case? Your Honor, your question was, how come we did not file our arguments on time? We've explained those obstacles, and we've addressed this concern, this obstacle to you. So please help us to deal with that obstacle. This problem should not be occurring. Let me, please allow us to consult briefly.
Okay,
All right. The court will talk with the prison management to find out what's the situation. If there's a problem, we'll find out ways to address it. The prosecution has heard that, and as the court, we will contact the prison to find out what's going on. If there's a problem preventing you from preparing your defense, which would be an obstacle to the smooth running of this trial. We will talk about that next. But you need to file your arguments by Tuesday, and we'll discuss more on Wednesday. Otherwise, we'll contact, we'll find out if what you say is true about the situation at the prison. That's all for today. The registrar should print out the document to be signed before we leave.
Nsabimana Calixte.
Nsabimana Calixte, please step forward and sign.
N'umwunganizi we.
And your lawyer.
Sengimana Herman n'umwunganizi.
Sengimana Herman with your lawyer.
Ni Maître Rugeyo.
Maître Rugeyo, right?
Sinyanga imbere. Rusesabagina.
Rusesabagina and your lawyers.
Merci. Mukandutiye Angeline.
Mukandutiye Angeline, please step forward.
Hazina Mutakamba Jean Berkimas. Mutakamba. Maître Mukarusiga Chantal. C'est ça, oui. Avocat wawe wasinye. Merci. Shabani Emmanuel na Nsabimana Jean Damascene alias Motage. Aze n'umwunganizi wabo Maître Uwimana Shani. Ande? Shabani Emmanuel. Nsabimana Jean. Shimimana Emmanuel, Nirora Marcel, Yamuremye Emmanuel n'umwunganizi wabo Uramije James.
iyo muri nyuma
iyo ninde
Bizimana Cassien, Nizeyimana Marc, umwunganizi wabo Maître Murekatete Henriette.
Bizimana
Nizeyimana. Sanzubukire Felicien, Munyaneza Anastase, umwunganizi wabo Twaje Amahoro Herman. Kwitonda André, Hakizimana Théogène, Ndagijimana Jean Chrétien, umwunganizi wabo Maître Mugabo Sharif Yusuf.
ninde Kwitonda André ninde
Chrétien. Byukusenge Jean-Claude, Nikuzo Simeon, Habanganyimana Joseph, Ntibiramira Innocent, n'umwunganizi wabo Ngamije Kirabo Guido.
ninde ninde
Zamucyane. hari n'abaregeye indishyi Maître Nditiye Yusuf.
Maître Ndutie Yusuf for the party of those seeking compensation.
Na company Alpha na company Omega. Attention. Karegesa Phineas. Udahunga Ladislas. Nyirabumveriane n'abamwunganira aribo Maître Mugabo Fidèle, Maître Mukashema Marie Louise na Maître Umulisa Alice. Bahagarariye nande hajya? Ntabwo yaje.
ntabwo yaje kuki bareba umwana bane mutajya mu
Tugiye kubahamagara. Bahagarariye nande? Mwese?
kuvuga metero yashishwa
Nabo murabahagarariye? Okay. Reka mubisinyire hamwe. Duhagarariye abarigenda ishyirwa mu mwanya. Ariko n'uyu muramuhagarariye? Okay. Hari n'abandi 84 bahagarariwe na Maître
There are rather 84 individuals represented by Maître Mugabo and Maître Umulisa.
Okay, mwakoze cyane iburanisha.
Thank you very much. We've come to the end of today's proceedings.